Okay, I think we'll get started now. I think there will be more people joining us as we go on. Right now, it says there's 17 participants, but I believe that they're supposed to be closer to 40. So we'll let them join as the time progresses. I'd like to thank you for joining us today for this interesting conference. My name is Randy Hell Giblin, and I'm the moderator for this session. And this session is assisting with legal matters, what the caregiver should know about estate planning, disability planning, and government benefits. If you think that you're in the wrong session, just go back to the home conference page and click on the title you want to attend. A reminder that this conference will be available for your viewing for 60 days after the conference with a link sent to you by email after the conference. If you have any questions during the presentation to Stuart, please write them down in the chat section. Stuart will be checking this chat section and he will be answering those questions. He will try to get to all of them as many as possible. Write down your questions and then hit enter. We recommend that you use the side-by-side speaker with the buttons in the upper right-hand side of your Zoom screen. And if you have any technical issues with the conference, please click on the email button on the conference homepage to submit questions that will be answered in real time. Please also keep yourself muted and your video camera off or on if you feel that you would rather do so. Today for this session, let me tell you, this is a topic that is so important when you get an Alzheimer's diagnosis. My husband, John, was diagnosed with young onset Alzheimer's when he was 62, and he died, unfortunately, 6 years later. We thought that we were prepared with whatever we needed to be done as far as legal matters. We were both lawyers, but when you get an Alzheimer's diagnosis, everything changes. And you find out that there are things that have to be done that you had never thought about, not only legally, but also medically, such as a healthcare directive. Alzheimer's, unfortunately, is a very expensive disease. I'm not certain what all the expenses are in 2021, and there will be a session about housing coming up in the second or third series of sessions. But I can tell you, when my husband was going through this diagnosis, just to have someone come in the house was like over $30 an hour. To have him involved in a day program was $80 a day. When unfortunately he finally had to go into a long-term memory care facility, it was over $9,000 a month. So in short, this is a very expensive disease, and you need to prepare for this. You need to prepare your estate. You need to see if there's anything that can be done as far as government benefits or disability benefits, which will help you. And if it can't be helped, then you just need to know, how am I going to prepare and plan for all of this? I'm honored today to introduce our speaker, Stuart Baer. Stuart has a very impressive resume. He's the partner and shareholder and president of the Chestnut Cambronne Law Firm. His practice specializes in wills, trusts, disability planning, powers of attorney, living wills, asset protection, and medical assistance, all things that you need to be aware of after you get an Alzheimer's diagnosis. Stuart is a native of Superior, Wisconsin. He received his BA from the University of University of Minnesota Phi Beta Kappa. You don't get to say that too often about anyone, so it kind of threw me off there. And he has a JD from the William Mitchell College of Law. He's distinguished as a fellow of the American College of Trust and Estate Counsel. He's been designated a Minneapolis super lawyer, as well as one of the top 40 estate planners in Minneapolis Super Lawyers magazine. He's also rated AV by Martindale-Hubbell. That's the highest rating a lawyer in the state can receive. He's a member of the Minnesota State Bar Association's Elder Law section, serving as past chair of the Elder Law Governing Council. He's a member of the Probate and Trust Law section, a member of the Real Estate section. He's also a current member of the National Academy of Elder Law Attorneys, and he has recently been elected to membership in the International Academy of Estate and Trust Law. He's a frequent lecturer and speaker at legal education seminars for attorneys and for financial planners and community organizations. In addition to all this, he's also an adjunct professor at the University of St. Thomas School of Law, where he teaches courses on wills and estates. Those are Stuart's impressive designations in writing. But let me tell you a little bit more about Stuart. About 4 years ago, I came to this very same conference and I signed up for Stuart's presentation. And I was so impressed by what he said and his ideas and recommendations that I signed up for a meeting with him afterwards, and he became our estate lawyer. And I can tell you, he handled everything brilliantly. And when my husband passed away, everything was easy and seamless. He did something that I thought was so special. He prepared, it's called a little doctor's suitcase. I'm just gonna hold it up right there. So that when my husband unfortunately developed seizures due to his Alzheimer's and we had to call 911 and have him taken to the hospital, I just grabbed this little suitcase which had our healthcare directives in there and our pulse in there, and it made everything so easy. So I can honestly say that I believe Stuart is a great attorney, and what he has to say is a wonderful explanation of what you need to know once you receive an Alzheimer's diagnosis. And I thank you, Stuart, for all you did to help us. So with that, Mr. Stuart Baer.
Thank you. Thank you, Randy. That's really a lovely, lovely introduction. I'm really quite touched. I'm kind of verklempt, as it were. So thank you on many, many different levels. I really appreciate it. As long as we're thanking, we might as well get this on the table as well. The organizers have been just wonderful. When I found out that Randy was going to introduce me, and she's become my dear friend, I was really quite touched by that. But everything was so seamless. I know that when you start to list names, you're always gonna, forget somebody. So I will just simply say Tabitha Durango and her team writ large are just wonderful, and they made this conference so well. But I especially want to thank you for attending the conference and choosing this session in particular. Over the next 50 minutes or so, we're going to have a wide-ranging discussion about the kinds of things that the caregiver should be concerned about in terms of providing assistance, guidance to a person who might have the onset of an illness. And there's no right answer for everybody, but I just wanted to get some general information out there that we can refer to from time to time. I did prepare a written outline. It looks kind of like this. In fact, this is exactly what it looks like. And you can find it by going to the conference homepage. And when you click on that, there's a series of purple tabs on the left-hand side. Go down to where it says session handouts. Click on that. Up will pop the different sessions. Go down to session number 8. We're session number 8. You click on that and you'll have the handout as well. During the course of our time, as Randy mentioned, I certainly want to take your questions as they arise, or I might keep the questions until the end, but I will certainly get to all the questions. But if you have a more personal question, something that you really want to get some more specified information, please don't stand on ceremony. Call me. My telephone number is right here on this form. You're not going to get a gotcha bill. That's not going to happen. It's not going to happen at all. But I'm happy to field your question and give you some advice and guidance and direction about whether it's legal resources or any other resources that I know of in the community to help assist another person who may have the onset of an injury. In fact, that's how my day starts. My day starts, I live in Mendota Heights, I work in downtown Minneapolis, I make the commute every day. I must admit the commute is pretty short during COVID, getting from Mendota Heights to Minneapolis. But invariably on my way, sometimes 7:30 in the morning, I kind of glance over to my phone. I know you're not supposed to do that. I like to see the emails that are popping up. And invariably, oftentimes the message email comes up. You know, the messages are accessible through email. And when I get to the office safely, I open that email, and it's a phone message, and it's often from a person providing care to another one. Maybe there was a recent diagnosis of an illness such as Alzheimer's or dementia or another type of illness, or maybe the person with the illness has had it for some time, and just now the person who is the caregiver is getting around to it, trying to assist that person. I really feel sorry for the caregiver because oftentimes they're behind the eight ball. They really don't know about the person's affairs that they're trying to help. I mean, imagine an adult child trying to help a parent. And you know, we're all Minnesota nice, even though some of us did grow up in the East in Wisconsin. I get that. But we don't want to impose ourselves in a parent situation. And so there's always been that line of not overstepping boundaries and not finding out about information. But it's important. And so the caregiver is has a number of questions. Does the person I'm trying to help have a will? Or do they have other legal documents? How am I going to afford the high cost of care? As Randy mentioned, the cost of care is so high. I've been telling people that the cost of care in a care facility, like an assisted living facility or a nursing home facility, is about $10,000 to $12,000 a month, depending upon the facility and the types of services being offered. So I may get this call from this, say it's an adult child, and they want to help their parent, and they may have posited the question as, I'm so-and-so, I want to help my parent. I think they have an old will. I found this old will from 30 or 40 years ago. It's when I, the adult child, was younger, and it mentions who I would live with in terms of the guardians. I don't want to live with the guardians anymore. Fine, I know, a little humor, fine. But I think we should update the will. And I want to tell you that when I meet with the family, and I do want to meet with the person who has the onset of the illness, whether it's by Zoom or whether it's by phone conference or even back in the pre-COVID days, and hopefully those days are gone very soon, me even coming out to the place where the person is at and having a conversation with them. I want to tell you that I have three things in the back of my pocket. And those three things are the three main subject areas that we're going to talk about this afternoon. The first is disability planning, having the right kind of documents in place so that if the caregiver needs to step in at any moment or other people need to step in and provide assistance, they have the right legal documents in order to do that. The second category is what we're going to call succession planning. It's a big category, and we're going to lump in all of those questions that we've always had: beneficiary forms, account ownership arrangements like joint ownership arrangements or transfer on death ownership arrangement. How does that intersect with having a will? Should you have a will, or should you have a revocable trust as your primary estate planning document? And what about taxes? What about estate taxes, both on the federal level and on the state of Minnesota level? So that's the category, the second category, what I would call succession planning. And then the third category is just, I would call it government benefits, risk management. What are available resources to provide or to seek in terms of long-term care? And also a good dose of other things for the caregiver to make sure their own financial house is in order and they're on stable ground as well. So those are the three things we're going to talk about. So the first thing, and if we go to the outline and we look at page 1, disability planning. There's two sides to disability planning. One is financial and one is medical. The financial piece is what is known as a financial power of attorney. And you might have heard the term differently. You might have heard it as a durable power of attorney or an attorney, power of attorney for financial matters. something like that, some variation, something about the word financial. And this document empowers others, meaning who the person with the onset of the illness, who they would empower to handle financial matters for them. So the way I explain it to my clients is everything a person does financially on a regular monthly basis, this document would empower the representative to handle those matters. So we can think in our own mind's eye what we do personally on a regular monthly basis. We receive our bills and we mark them for payment, and then ultimately we make sure they get paid either by check or online. We receive account statements for our assets. And I have to admit, in markets, when markets are going up, I'm very anxious to open my account statements, whether they come electronically or through the mail. And when markets are down, I'm kind of hesitant to look at those account statements. But review the account statements, make sure we understand what's going on, that sort of thing. The credit card bill comes, and before we pay it, we look closely at it to make sure there's no wrong charge on it. There's no charges from overseas or something that looks amiss, right? And then, of course, we file our taxes. So that's really the role of the person under the financial power of attorney document. Now, I might be speaking to a client of mine. Let's say it's an older man, and he tells me that when I talk about the document and I ask him the question, who's going to be the representative? Well, he might say, based on his world where he grew up, he might say, well, shouldn't it be my oldest child? My oldest son should serve in that role. Well, I'm more interested in skill sets than a person's rank in the family or gender in the family or anything like that. The skill set you really need for this power of attorney is somebody who's fairly well organized, somebody who is going to get from point A to point B, somebody who also has a bit of self-awareness, so they know what they don't know. And if that's the case, they're going to seek an answer. For example, if they need to work with a financial advisor to maybe boost income or have certain investments that they're interested, making sure their money is working as hard for them as it could. If there's a tax issue, they're going to reach out and hire an accountant. That's the kind of person that you want to handle that role. Sometimes in families, they name multiple people to handle that role. And whether they decide that the people have to act jointly, the representatives, or if they can act separately, we need to discuss that to see what the best solution is. But oftentimes people will name multiple children or multiple people to handle that role. They'll allow them, the representatives, to divide and conquer. One person might be good at bill paying, one person might be good at overseeing the investments, and it doesn't burden anybody with the complete responsibility. So every family is different. You're going to get that theme throughout the day. And it's just a matter of trying on what's the role, who best matches up for that, how best to accomplish that role. That's the idea of the financial power of attorney. When we do sign the financial power of attorney document, I like my clients to sign 4 duplicate originals. So you may want, when you're working with your own attorney, to suggest that maybe you do sign 4 duplicates as well. There's nothing magical about the number 4. It's not like it's more than 3 and less than 5. There's nothing magical whatsoever. But the reason I want multiple duplicate originals is that sometimes a financial institution might want to see an original, and they might want to hang on to that original until the next institution wants to see an original as well. So by having multiple originals, then it allows the caregiver to speed the process along, so that while they drop off the first document at the bank and the bank wants to review it, they can go with the next document to the next institution and present the document as well. It just makes things much more efficient. So that's the idea with the financial power of attorney document. The other side of the coin is the healthcare directive document. That's what Randy alluded to as well. That does a number of things for us. That appoints representatives to make healthcare decisions. It also provides instruction as to the kind of care a person would want if faced with a terminal condition. The document also goes on further and allows people to state whether or not they want to be an organ and tissue donor. And, many of my clients, older clients, think that they've aged out of organ and tissue donation, but they haven't. Certain organs, your skin being the largest organ in your body, is ripe for transplantation, the cells or cornea. And so certainly it's a matter of personal philosophy. But I try to push my clients, hopefully in a gentle way, to state whether or not they want to be an organ and tissue donor. It doesn't matter to me. I have no, it's not my place to say what they should do, but I can say that being affirmative and saying whether or not they want to be an organ and tissue donor does make it easier for the family. On the worst day of the family's life, maybe losing that person, that at least they're given the gift of knowledge, knowing what the person wanted in terms of organ donation and whether or not they wanted that to be so. The other thing the document allows is for a statement about whether a person wants burial or cremation. If it's burial, where, what cemetery? If it's cremation, what's to happen with one's ashes? Again, I want to push people about that. Should the ashes be buried or placed in a columbarium or scattered? And if so, where? It's just about knowledge. It's just about knowledge. Now, what Randy mentioned is that she held up this curious envelope saying doctor in suitcase. And I applauded because it's like, it's great. It's wonderful. I too like to do 4. Thank you so much. Great visual. I too like to do 4 duplicate originals of the document. And I know many attorneys do this as well, but as a courtesy, and it looks like someone's playing around with the Zoom, but welcome to the age of Zoom. As a courtesy, I like to keep a set for my clients just to email them or fax them wherever they need to be. And it's not me. I mean, that's the standard of what many attorneys do. But the folder that Randy held up was, I wanted Randy, and she did, to take that document right to her main clinic or her different physicians and have it entered into the medical records. It's typically scanned into the records. The physician's office then doesn't want to hang on to paper. They typically give that back. And so I told Randy to put that at or near her suitcase so that it's handy. So if they need to pack a bag on a more emergency basis, the one less thing they have to worry about is, where's the healthcare directive document? It's already packed in the suitcase. It's already set to go. I also like to do this. I also like to assist my clients in sending it to them or their care providers by email, so it lives in a smartphone. Nobody leaves home without their smartphone anymore, or so it seems. And so it's important to have the document handy right in the palm of one's hand to show that one has authority to make healthcare decisions. The document typically has a HIPAA release associated with it. And so it's right there in the palm of one's hands. Let me go to our chat. I see we have a couple of questions, and let's see what I can do. First of all, power of attorney also allows checking into any legal matters such as insurance questions, Social Security benefits, et cetera. Correct? Yes, correct. Absolutely correct. And so I would say general financial business endeavors, anything a person could do in their own right, the power of attorney document typically is written in a broad way to allow for that. Next question, does a certified copy filed with your county worker the same, filed with your county work the same as the duplicate originals? So does a certified county, first certified copy work the same as a duplicate original? It should. It should. How's that for a legal answer? It depends, right? Well, it should, because under our law says a certified copy is just as valid as an original. And usually under a statute, a certified copy means that the drafter of the document, your attorney who had drafted the document for you, or if it was not an attorney, if it was just self-drafted, whoever was the person who drafted it is certifying, stating under oath, penalty of perjury, all that, that this photocopy of the document is a true and correct copy of the original. Should work. However, you know, us lawyers, we always play to the lowest common denominator. This is in the medical context, and I used to make this joke years ago, and then it kind of waned, but I think now it's coming back because people remember the character from the movie One Flew Over the Cuckoo's Nest, Nurse Ratched. I always play to the Nurse Ratched standards, as it were. Yes, I know what the law says, and yes, the law says that a certified copy is certainly as good as an original, but you might run into an authority at a financial institution or even in the medical context who's not going to accept a certified copy. So it's just good to have the multiple duplicate originals. Other question, healthcare directive, should that be filed for certification as well? Well, it's not filed in any place per se, but here's another aspect to the healthcare directive, and it's in our outline. It's C, it's on the top of page 2. And it's the POLST order, the provider orders for life-sustaining treatment. And the provider order is really based on the healthcare directive document. The healthcare directive document is a statement of wishes. If I'm unable to speak for myself, I would want this kind of care, typically palliative care. And I believe that life would no longer be worth living when given these circumstances. So the medical provider, the doctor, provides this medical order, very much akin to DNR order, a do not resuscitate order or do not intubate order. And the order is actually a medical order saying that we're going to follow what the person's wishes were in their healthcare directive document. Why would a POLST order be necessary? Well, it makes it clear, it makes it more concrete what a person's wishes were in a healthcare directive document. And also it protects, particularly in the event of, well, if there's any dysfunction in the family. So mom has appointed her daughters, her 2 daughters, 2 of 3 daughters, to be her healthcare decision makers. And her plans are pretty well clear, and her daughters think like her. They share her philosophy around medicine. But there's a 3rd daughter, and she had a strained relationship with her mother and has a strained relationship with her sisters. And mom's concern is that if mom needs to rely on this healthcare directive document at the end of her life, that no one's going to upset the apple cart and no one is going to come in, specifically this other daughter who's really not necessarily involved in mom so much, but upset the apple cart and maybe have mom's healthcare go in a different direction. So preventing that, then it would be very important to have a POLST order, a physician's order, a medical order saying this is mom's wishes and this is what we're going to do in order to follow the wishes. Another question. My mom is past understanding the document to have her sign more originals for the healthcare directive. Okay, I get it. So don't beat yourself up, please. You did what you could do, and we'll play the cards where the cards come down. And that is, if in fact we do run into Nurse Ratched, we have options. Nurse Ratched has a boss. Maybe the boss wasn't in the movie, but Nurse Ratched has a boss, and we'll ask for a care conference and we'll work our way up the chain of command and we'll advocate as best we can. So please don't worry about, I didn't do everything completely perfectly. I didn't hit all 10 steps. Enough. You did plenty. At least mom has the healthcare document. Okay. All right. Let's move to the second subject, succession planning. Here's a tip to impress your friends at your next social gathering. It's after COVID. Maybe it's the 4th of July. You're seeing your friends for the first time after we've had the discussion about how we've survived COVID. And maybe there's a lull in the conversation. It just is kind of, you're wondering about the next thing to talk about. Well, you could always bring up the subject of, say, what takes precedence? Asset ownership arrangements and beneficiary forms, or a person's will? Nothing will stir up the conversation more than that conversation. But I think it's a question that we need to unpack. Let me tell you a real life made up situation, and you tell me what the answer is. So we have mom, And she did a will a number of years ago, and she left all of her assets to her three kids in equal shares. That's what the will says. She has two daughters and a son, and she named the oldest daughter as the executor of her estate. And so that's what the will says. It says everything goes to the kids in equal shares. But over the years, as mom has certain accounts, and well, after dad passed away, she updated the records. She has an IRA account, and she just named her son as the beneficiary on that IRA account. And then she has a number of bank accounts, and if this is our mom's own generation, she probably has a bunch of bank accounts scattered through all kinds of different financial institutions. And she has the toaster and the blender and all of those appliances that were offered as premiums many, many years ago to show for opening up these DIF accounts. But they're all owned jointly for the most part, and they're owned with the youngest daughter, those accounts. And then she heard that you're supposed to do something with the house so it's protected from the nursing home. And so she did a deed to change the ownership of the house, and she changed it to the middle daughter, right? So we have oldest son, middle daughter, youngest daughter. Oldest son has the IRA account paid to him. Middle daughter has received the house, and the youngest daughter has all of the accounts, the joint accounts, the bank accounts. So who gets mom's assets? Well, the way the law works is that whoever is the beneficiary, or whoever is the joint owner, or whoever has received a lifetime gift, those are their assets. They get those first. The will only covers the assets that are just in mom's name when she passes away. Well, what assets are in her name? Well, if we think about it, I guess the only thing that's really technically solely in her name is the toaster and the blender that she got from the banks. So this can cause some problems in families, as you can imagine, because if mom's idea was to treat the children equally and fairly, well, with an IRA account, as you know, when monies have to come out of an IRA account, they're subjected to taxes. So that might have a certain value to it, net of taxes. So that might have a value here. Here's my visual. And the house might have a value here. And the bank accounts, they may have a value way down here. So you can see the three different levels of assets are not equal. And that can cause a hardship among the children in terms of both the interpersonal relationships among the children, pitting them against each other. I'll be blunt about that. And also tax consequences about if the children even do decide to equalize things, then there may be tax consequences to the children in terms of splitting up the assets. So one of the things that that lawyers do when a person is considering a will or a trust is we want to make sure we understand their assets so that whatever the estate plan is, say it is equally to the three kids, then we want to make sure that asset ownership arrangements and any lifetime transfers, gifts are all equalized as well. So that would look like in this situation, making sure that all three kids are listed as the beneficiaries on the IRA account, making sure that all three kids receive the home as it was transferred, making sure that all three kids are either joint owners on mom's bank accounts with mom or set up in what's called a payable on death or transfer on death ownership arrangement. That's a beneficiary arrangement for bank accounts, so they're automatically paid. That alleviates a lot of problems in the future. You know, the test of a good estate plan is this. I often have thought, well, if you can avoid probate, we'll talk about probate, that's the court system involved in settling the estate. If you can avoid that and the costs of probate and whatnot, well, that's a good goal. And that's a worthy goal. And also taxes, if you can save estate taxes, well, that's certainly a worthy goal as well. But I think the real test of any good estate plan is making sure that the first cousins get along. By that, I mean this, in the situation with mom, right, with the oldest son and the middle daughter and the youngest daughter, let's assume that they all have children. Those three children have children. So mom has grandchildren. Wonderful, terrific, great. Well, those grandchildren for the different children are all first cousins. And if mom's estate plan is not clear, And nobody's a bad actor here. Notice I didn't say anybody's greedy or anything like that. It's just plans are just not clear. If plans are not clear, then the kids might be pitted against each other, and that will affect the grandchildren's generation. I know it will. And so the grandchildren won't have a close relationship, the first cousins, right? And so that's the real test, to make sure that the plans are not upsetting, that they're going to pit the children against each other. So the first cousins can have a good relationship. Let me go to more questions here. Um, how do you find where bank accounts are held if you don't know? Oh, is there a way to search this if you have a POA? Yes. Would it show up on a credit check? Okay. So a couple of tips. This is really important. I'm so glad whoever asked this question, because as the caregiver, we're behind the 8 ball. We're dealing with our mom. Sometimes we have some family dysfunction going on in our back pocket, and now we're supposed to find out where the bank accounts are that mom has, because she's been a very close to the vest Minnesota kind of person that we don't share this information, right? So the power of attorney is going to be your key. And I want to tell you that in the Twin Cities, 80% of all depository accounts are in 4 to 6 financial institutions. It's the large banks, it's US Bank, it's Wells Fargo, it's what used to be TCF. I think it's still TCF until it becomes Huntington Bank in the future. It's Bremer Bank, and it's the larger credit unions. It's Truestone Credit Union and Wings Credit Union. Those 6 institutions, and that's a good start. So by going to those 6 institutions with your power of attorney and say, here I am, and you need the document, certified copy or photocopy or original, whatever they'll take. But again, I mentioned we're playing to the lowest common denominator, so have the original. But go to those places and inquire about the accounts. That's a real helpful sort of thing. There might be some local banks too. If mom is living in St. Louis Park, there's some smaller local banks to check out. Associated Bank is also a larger presence in St. Louis Park. That's one thing. The second thing is go back to old tax returns and see what interest mom was claiming and from where. That's another way to uncover that as well. And so maybe if mom has kept tax return, I don't know what I'm saying, parent has kept tax returns for some time, or if they've used an accountant, maybe the accountant has records of the tax returns, even though they've the physical hard copy have long been thrown away. Those are some ideas in order to uncover that. And you say, oh, she lives in another state. Well, blow that out of the water. Anyway, you've got the idea. You're going to go to the major banks in that area and make inquiry. The key is the power of attorney document will unlock those doors for you. How do you navigate major financial issues, needing to file bankruptcy and legally shutting down their businesses? Boy, that's a question that I would like to help you more personally, giving you some resources and negotiating that. But the power of attorney, if drafted as a very broad document, allows you to take on legal matters on behalf of the person you're trying to help. So you can file bankruptcy on their behalf, and you can do a number of other things. Great. And then finally, somebody says, are we going to cover assisted living facilities? Yeah, in this session, absolutely. It's a broad topic area. Let me just talk a little bit about the difference between a will and a revocable living trust. And people wonder, well, what are the tipping points for that? When do I use a will? When do I use a revocable trust? Well, I listed, let me just explain. A will without beneficiary forms, a will addresses assets solely in a person's name when they pass away. A will simplifies the probate estate settlement process, the court system. It turns it into an administrative procedure, but it doesn't avoid probate. So for a number of people, they want to take the extra step and avoid probate. Now, I talked about the situation where we had mom with the adult son and then the 2 daughters, and that was just an outright straightforward distribution of assets. That situation, likely mom would not need to have a revocable trust because she's already achieved probate avoidance anyway by setting her assets up to be paid automatically to her kids. But what if we had a different situation? What if it was a more complex situation? Son, he needs his assets set up in a special way because he's financially secure, and we want to save taxes in his estate. And middle daughter, she has some special needs, and so assets need to be set up in a certain way so she doesn't jeopardize her eligibility for government benefits. And youngest daughter, she's fine. It's not that. We just can't stand her husband. And we're afraid that he's going to take advantage of her when she passes away and take all of her inherited money. So we need some sort of a protective trust for her. Because the estate plan is a bit more developed, more, I'll just say complex, because of the family complexities, then probably a revocable trust in order to avoid probate would be the right thing to do, because there wouldn't be a way to avoid probate with that level of complexity in the estate plan. So on the top of page 4, I listed factors that are tipping points. Usually for younger people in the asset accumulation phase of life, wills are fine. Think the young family with minor children. But as a person gets to be middle-aged, they're maybe have retirement on the horizon, or they're in retirement, then maybe a revocable trust is right for them. The nature and extent of assets, the mom I described had a house and financial assets. Well, what if a person has a more sophisticated estate? They have a home in Minnesota and a cabin in Wisconsin and timeshare properties in other states and a condo in Arizona. Because they have real estate in multiple states, they'd have to go through a probate procedure for that. So a trust avoids the necessity for probate in all those states. The nature of the estate plan, well, that's what I mentioned with the son and the daughters. If it's a more complex plan, probably a revocable trust. If it's a married couple and there's actually a necessity to double the exclusion amount for estate taxes, I'll get to that right next. We want some assets in one spouse's name, some assets in the other spouse's name, and no beneficiary forms associated with that per se. We would guarantee ourselves 2 probate procedures to save taxes. So a better structure, a better scaffolding for estate tax savings is the revocable trust, because it avoids both probates. And then finally, confidentiality. And I think that's the big tipping point about why this dreaded P word is around, probate. It's around because in addition to the cost of attorney's fees and court costs and time, it takes longer to settle the estate. Probate it affords a lack of confidentiality. There's a public record at the courthouse. So it's not, broadcast in the newspaper or makes the headlines of the newscast about a person's estate and their net worth. But there is a public record at the courthouse. And in the best case, one wants to keep that away from being in the public domain, where it could be available to telemarketers. Telemarketers, for example, would want to know, I should just say marketing in general, would want to know if a person comes into an inheritance, because that means that they're now have certain expendable assets. And that's the best case scenario. Unfortunately, we live in a world where there's a lot of unscrupulous people and they prey upon others, and they can go down to the courthouse, and it happens, particularly when one spouse passes away, and an unscrupulous person makes friends with the surviving spouse, and there's all kinds of reasons to be concerned about that. So confidentiality means there's no public record of assets, and therefore that's the byproduct of avoiding probate, and that's a real benefit to that. Estate taxes, I touched on that a little bit, but it's in the materials. The federal government excludes, for a married couple, the first $23.4 million. And the state of Minnesota excludes the first $3 million. There's a strategy for married couples to double that exclusion amount. But that means separating the assets. And that's why the revocable trust works so well, because at the death of the first spouse, there'll be no probate procedure, no court intervention. And that first spouse, the first deceased spouse, will be able to take advantage of their $3 million exclusion. And then at the death of the second spouse, again, no probate will be necessary. And that spouse will be able to take advantage of their $3 million exclusion. The savings between $3 million and $6 million of assets, the tax savings is about $450,000. So it's quite considerable. Now, how did I get there? Well, the tax rate starts at 13% in Minnesota, goes up to a maximum rate of 16%. Figure a weighted rate of 15%, right? So 15% of the difference between the 3 million exclusion and the 6 million exclusion, 15% is that $3 million piece, right? And the $3 million piece multiplied by a 15% rate is $450,000. So it's quite considerable. I think of estate tax as more of a voluntary tax. And the more that one engages in planning, the more one is certainly able to achieve estate tax minimization, if not complete avoidance. Substantive provisions in the will and the trust, we sort of talked about that. And this is something to explore with all family members, whether the assets should be held outright or in a testamentary trust. What's gained in popularity is to have assets set up in a continuing trust arrangement for the child, so the child can take assets out of the trust from time to time, but the child's not the direct owner of the assets. And one of the legal themes running through planning is that if a child doesn't own the assets directly, then they're not necessarily subjected to the child's creditors, and they're certainly not available to split up in the event of a divorce. So, as we're confronted with those issues about creditors and divorce, one wants to provide protection for their beneficiaries. So they often set up a kind of a trust, which is called a self-directed trust, where the beneficiary is in charge of the assets, but they're technically not the owner. It's a legal construct, I get that, but it's become a very popular way to provide for one's beneficiaries. The byproduct of that is that when the child passes away and there's assets that are remaining in their trust, those assets go on to their children, the grandchildren. They tend to bypass the surviving spouse, which is okay for many families, because the child who passed away, they may be leaving monies to their surviving spouse. And the concern always is that if monies go to the surviving spouse of a deceased child, that surviving spouse could get remarried, and those monies could inadvertently leave the family. I touched upon a supplemental deeds trust. That's a special kind of a trust that doesn't jeopardize the ability for a person to receive benefits if they need it. It's usually for a person with the onset of a disability. And so oftentimes parents or grandparents set up assets in a supplemental needs trust to benefit a beneficiary. The representatives, the terms, people get confused about the term executor. And when I went to law school, I think the law was just changing, and this is in the 80s. The term executor actually connotes a male. Just like if those of you that know Hebrew, there's Hebrew words that have a male connotation. It ends with the IM ending, and for a female, it's the OT ending, and that's common with a number of languages. The word executor is actually a Latin term, and it connotes a male. And so a number of years ago, Minnesota, as most states, got away from using that term, and they use a more gender neutral term, the term personal representative. So the personal representative is somebody who settles the estate. And the skill sets of the personal representative is very much like under the power of attorney document. Somebody who's organized, somebody who is smart enough to know what they don't know and is going to seek out help. Those are the skill sets that we're looking for. The trustee is somebody who oversees assets held in trust for another person. I mentioned in the self-directed trust, it can be the beneficiary who's also the trustee. In a supplemental needs trust, it likely would be somebody other than the beneficiary, other than the person with the disability serving as the trustee. And the guardian's in charge of a person's well-being. Now, we know what for families with young children, that they often, they need to appoint a guardian under their will, somebody charged with raising the child until the child reaches the age of majority, in this case, under our law, age 18. But if a person has a child with a disability or a friend with a disability, they can also be appointed their guardian as well. And that's another rule for the caregiver to be appointed the guardian for that person. The difference between serving as the guardian and then serving as the representative under the power of attorney or the healthcare directive document is that we may have a person who's not even capable of entering into those documents, financial power of attorney, healthcare directive document, in the first instance because of a mental disability. And so then the person would be the guardian, or because the person, say under the power of attorney, let's just focus on that. The person under the power of attorney still has concurrent power. And if they're doing things that are harmful for themselves, they're wasting their own assets, they're not following good medical direction, advice, and guidance, then we actually need to go to court and have that person's rights just change to the person who's going to be the guardian or conservator. So it's a rather drastic step in that case, but it's an important step to provide for protection of the person who has the onset of the disability so they don't harm themselves or harm others. In the last go around here, and then I will get to some more questions, I just want to hit the idea of risk management, and this will back into long-term care options. The issue with risk management is, first of all, for the caregiver to just make sure that, and this might be a married spouses or partners situation, make sure one has good disability insurance for themselves. That's an income protection stream. It used to be that employers would often provide disability insurance as part of the benefits package, but more and more employers have gotten away from that over the years. And also a person might find themselves in a period where they're an independent contractor. They don't work for a company per se. And so it's good to have good portable disability insurance. It's just a check-in that I want to make sure that my clients address in terms of the risk management. Life insurance, make sure that they have their own life insurance in their name. And this applies maybe not so much in the caregiver context, but if we have partners or spouses who are raising children, and one may be unemployed or underemployed for pay outside the home. They're certainly working hard within the home in raising the family, but that's often overlooked. That if they were to pass away, the person who is providing for raising the children, in a sense, caregivers, if they pass away, it's going to cause a real hardship for the spouse who is out in the work world and is working for pay. Because to replace all of the things that a person does, it's the schlepping factor. I can't think of it in any other way, but schlepping around the kids and taking care of the house and doing this and that and the other thing, that's really an expensive proposition to replace. So I think sometimes people overlook that. It's a twist on the caregiver concept, but it's still an important thing to consider. And then asset protection planning, just making sure that you have good insurance coverage in place over and above your regular limits. There's something called an umbrella liability policy. It provides additional protection, and it's unfortunate, but it's a reality that we live in a very litigious world, and so it's good to have that extra type of insurance, umbrella liability coverage in place. The last issue I want to turn to, though, is long-term care. And I want to talk about the three main ways to pay for long-term care: private pay, long-term care insurance, and then medical assistance. Medical assistance is our implementation in Minnesota of the federal Medicaid program, and it provides benefits for those living in care facilities, either an assisted living facility or a nursing home facility. Where I start in the discussion is I want to explore with my clients whether there's the possibility for private pay, or whether there's the opportunity for long-term care insurance, or maybe the client has long-term care insurance. In my view, and this might be rather provocative, the least desirable planning method is medical assistance planning. And I say that openly and honestly because I don't sell insurance. I don't do financial planning. I'm an estate planning lawyer. I make my money by people who engage in medical assistance planning, but yet I don't think that's the best option right out of the box. I think certainly if a person hears that a long-term care facility may not take government benefits, and certainly the government doesn't pay for in-home care in a home setting. This is skilled care. This is if a person has Alzheimer's, for example. I think that's an aha moment for a lot of people in terms of thinking they're going to get on government benefits and instantly can dictate where they want to receive their care. In terms of the long-term care facility, even though a person might be eligible to take benefits, a lot of the facilities, because they're structured, may not allow medical assistance benefits until a person has lived there for a year, 2 years, whatever their internal requirements are. They want to see a person be on private pay for those initial years. And certainly the government doesn't pay for benefits for in-home care as well. So I think hearing that for people that may be looking at other alternatives, like does a person have enough financial resources, or should they work with a financial advisor to try to boost their assets or income just in some regard to assist in meeting the cost of care? Is there the possibility of long-term care insurance? Of course, even before a person gets sick, what can be done in terms of those aspects to make sure that a person has the ability to be on private pay in some way? Because when you have the ability to be on private pay, that's the whole idea about your own autonomy. And it's not getting on a soapbox about this personal autonomy and people should take care of themselves. That's not it. That's not it entirely. It's simply that when you have the checkbook in hand, you can make the decision about where you want to receive the cost of care. Under the medical assistance benefits, that could be a subject for another day. But if you're a married couple, the most the well spouse can keep is about $130,000, and the homestead property and a motor vehicle and the household goods and furnishings and prepaid funeral and burial expenses. So basically 130,000, the homestead property, motor vehicle, household furnishings, and prepaid funeral and burial arrangements. So you can see it's not much, most certainly. And if you're a single person and you're not able to live in your home, the most a person can keep is $3,000 of assets, plus their household goods and furnishings, plus a motor vehicle, plus prepaid burial arrangements. So you can see it's not a very generous program, and one really needs to spend down their assets, reduce their assets in a timely fashion in order to be eligible for benefits. And the other thing about asset protection planning, medical assistance planning, is that one certainly can't transfer their assets, gift their assets on Monday and expect to be eligible on Tuesday. And so there's a 5-year waiting period as well. With benefits, I just wanted to point out the last page, page 8, and that's veterans benefits aid and attendance. And this is something that's overlooked. But if a person is looking for some government benefits and they served in the armed services during a time of war, they didn't have to see combat, they didn't have to be stationed overseas. But if we have, say, a person who served during the Vietnam War, they're entitled to a monthly benefit. And here's the thing, that monthly benefit will pay for in-home care. That's a great benefit to have, because if a person has, say, the onset of Alzheimer's, but they're able to remain living in their home and maybe their spouse or partner is providing some care, or the adult children are looking in on that person, then maybe there's a way for them to receive this benefit and structure their other assets to be protected. And so they can still receive in-home care as long as they possibly can before they need to transition to a care facility. So here's the
Oh, I'm sorry, Stuart. I was going to say, I'm sorry, we're at the end. This is just such a complicated subject. I would encourage anyone, if you still have questions, to call Stuart, or if not, to find a lawyer that you're comfortable with. I can tell you, my own private advice, and that is being a lawyer myself, is that you need a lawyer who is competent in estate law, because this, everything Stuart has said has been so informative for me, even though, you know, my husband's passed away. It's just something that you need to think about. Again, I encourage you to do it as soon as there is a diagnosis. And again, if I might say one more thing about Stuart, when you find your lawyer, find one who is patient and find one who is caring. My husband, when we first went to see Stuart, was having a really bad day, which often happens with people who suffer from Alzheimer's. There's good days, there's bad days. He was having a bad day. He did not want to be there, which put more stress on me. And Stuart just made it much more easy to go through this estate planning. So I encourage you to seek more help, to find someone who's competent in this area, and do your planning ASAP. We're at the end. Thank you again, Stuart. Your information has been so exceptional. I'd like to remind the participants to fill out the evaluation, go back to the homepage and fill that out. And then we have a 20-minute break, and we start again with the third session. That will be at 1:35. So thank you everyone for attending this session. And again, thank you very much to Stuart Bear.
Thank you, Randy. I see that there's some other questions. Just email me the questions. You'll see the email, those that I didn't get your questions, and I'm happy to answer. Some are a bit more involved, so I want to give you greater direction, okay? Thank you for having me. I appreciate it. Have a great day.
Thank you.